Welcome to SB&M is Here, the State Bar of New Mexico's official podcast. In this series, we'll discuss topics such as professional development, tools of the trade, and mental and professional well-being. Connecting the legal community across New Mexico, SB&M is here. Hello, everyone. Welcome back to SB&M is Here. If you haven't listened to our first few episodes, they will be available on the listening platforms of Spotify, iTunes, or YouTube, as well as the State Bar's website. Make sure to subscribe on your preferred platform to receive notifications when a new episode is ready. This episode is sponsored by the State Bar of New Mexico's Legal Services and Programs Committee. So for this two-part episode, we're going to talk about two big topics surrounding COVID-19, evictions and unemployment insurance. These brief Q&A sessions will be for legal professionals who do not practice in this area and for members of the public who want to learn more about state updates regarding these topics. This is by no means an exhaustive episode of information, nor is it formal legal advice. But this episode is going to be a guide for some basic misconceptions about the eviction process during this time, which is early August 2020 as of this recording. Our episode today will be moderated by Asia Brooks, the president of the New Mexico State Bar Foundation and member of the State Bar of New Mexico's Legal Service and Programs Committee. We also have Riley Massey, who is an attorney from New Mexico Legal Aid, who will be answering some commonly asked questions. And ladies, thank you both for taking some time being here today, and feel free to take it away.
Thank you, Morgan. As Morgan stated, I am Asia Brooks. I'm the Foundation President of the State Bar of New Mexico. I'm also on the Legal Services and Programs Committee. And before we get into the episode on evictions, I just want to talk a little bit about New Mexico Legal Aid, the organization that Riley is from, that helps provide assistance to New Mexicans. So New Mexico Legal Aid provides free civil legal assistance to low-income New Mexicans. New Mexico Legal Aid's areas of practice are housing law, consumer law, domestic violence and related family law issues, and public benefits. New Mexico Legal Aid also has a Native American program, a volunteer attorney program to coordinate pro bono services and clinics, a low-income taxpayer clinic, and several other special project areas. They have offices across New Mexico. Applicants can apply for services by phone at 833-545-4357. The intake line is open Monday through Friday from 10 a.m. to 3 p.m. People can apply online anytime by visiting www.newmexicolegalaid.org. Qualified applicants will either receive advice from an attorney by phone or representation in court if the case is within priorities and there are available attorneys. For information on common legal issues, people can also visit www.lawhelpnewmexico.com, which includes New Mexico Legal Aid's Renter's Guide, which is an overview of landlord-tenant law in New Mexico. It's very, very helpful. So I suggest if you have any landlord-tenant issues, you go to the website www.lawhelpnewmexico and check out New Mexico Legal Aid's Renter's Guide. So today we are going to be speaking with Riley Massey. She is a staff attorney at New Mexico Legal Aid, and she is going to be answering a few common misconceptions about evictions, because we know that during this pandemic, there have been a lot of changes in this area of law, and so Riley is just going to help us understand what is going on with evictions during the COVID times. So let's start off, Riley. Can you first tell us what is the general process for evictions in New Mexico?
Yeah, hi, Asia. Thanks for having me. So generally, there are three bases for eviction in New Mexico. The most common is non-payment of rent, and that's if the tenant has not paid rent, the landlord can serve the tenant with a 3-day notice of non-payment of rent. The notice must state the amount owed and how the tenant can pay it. That's by check, cash, check, or money order. The tenant then has 3 business days to cure the notice by paying the landlord the full amount. If the tenant doesn't cure the notice, the landlord can then file for evictions. In Albuquerque, evictions are filed in Metropolitan Court. Outside of Albuquerque, they can be filed in Magistrate Court, but they can also be filed in District Courts. Once the landlord has filed a petition for restitution, which is the legal term for eviction in New Mexico, the court will set a hearing, generally within 7 to 10 days. At the hearing, the judge will ask what the outstanding amounts are and will provide the tenant with an opportunity to present any defenses, which I will get into a little bit later. The judge will then make a decision. If the judge decides in the landlord's favor, they will enter a judgment for the money amounts owed and will issue a writ of restitution. And that's the document that the sheriff uses to evict the tenant. Typically, the writ will be for 3 to 7 days after the date of judgment. If the tenant doesn't file an appeal or otherwise dispute the judgment when the writ is issued, the sheriff can come to the property and forcibly remove the tenant. Other bases for eviction include 7-day notices of material noncompliance with the lease agreement. So that would be things like having an unauthorized occupant in the unit, having an unauthorized pet, or causing disturbances in the unit. With the first 7-day notice, the tenant has the opportunity to cure the notice within 7 days. But even if the first notice is cured, if the tenant receives a second 7-day notice within a 6-month period, the tenant then loses the right to cure and the landlord can file for eviction after the expiration of the 7-day notice period. And another basis would be a 3-day notice of substantial violation. And this is only for very specific listed violations, including things like damage to property in excess of $1,000, unlawful use of a deadly weapon, unlawful action causing serious physical harm to another person, and then there are a few others. Notice of substantial violation does not allow the tenant the opportunity to cure, though the landlord must still wait for the expiration of the 3-day period to file for eviction.
Okay, so thank you for giving us that information. It sounds like a lot of people might fall into that first category, which is the non-payment of rent category, mostly during the pandemic when people are, getting laid off or they might have lost their jobs due to what's going on. So it sounds like non-payment of rent is one of those 3 categories. And you also mentioned, the 7-day notices where people, might have a pet or cause a disturbance or something like that. And then the third category might be like the smaller category of people, which is if there's like criminal activity or something going on. So thank you for getting into those 3 specific areas of potential evictions. So now let's talk a little bit about the coronavirus and its effect on evictions. Can you tell us, is there currently a moratorium on evictions due to the pandemic, which means like, you can tell us what moratorium means, but is there a moratorium on evictions due to the pandemic?
So this is kind of a common misconception that I see. People just have a perception that evictions can't be filed right now, which is not true. The Federal CARES Act prohibited landlords receiving any kind of federal subsidy, which includes like federally backed mortgages, low-income housing tax credit properties, project-based Section 8, and other project-based subsidies, and then tenant-based vouchers, including Section 8, as well as public housing. From charging late fees or filing for eviction from March 27th through its expiration. We don't know if Congress is going to extend these protections or not right now, but one important thing to remember, since the expiration, the CARES Act does require that landlords that were covered under the Act provide tenants a 30-day notice of intent to evict prior to filing for eviction. So tenants still have some time before these evictions will be filed. Additionally, the New Mexico Supreme Court issued 2 orders in March that stay issuance of the writ of restitution, which is, again, that document that orders the sheriff to evict people, for landlord-tenant cases and mobile home park cases. But that only applies to cases filed based on non-payment of rent, so no lease violation cases. And it does not mean that the landlord can't get a judgment against the tenant, and it does not mean that there won't be a court hearing. So the court can still issue a writ in lease violation cases or if the tenant doesn't appear at the hearing.
Okay, so it sounds like what's going on in New Mexico is that the Supreme Court said that the sheriff cannot kick you out of your place if you have not paid your rent. Like, that has to be the basis of the eviction, is non-payment of rent. The sheriff cannot come and forcibly kick you out. However, it sounds like the landlord can still go to court and have the court say that the money is still due to them, right? It doesn't prevent the landlords from going to court and trying to get a document that says that the tenant still owes them the money. Is that right?
Yeah, that's right. And that's an important thing to note. To get this protection, you have to show up to court and show that you can't pay the rent.
Okay. So now tell us, so how does a tenant who has not, paid that rent maybe, how do they get protection under the New Mexico Supreme Court orders?
So to be covered by the orders, again, the case has to be filed based on non-payment of rent. And there will be a hearing set. So a tenant that has been filed against will get a summons to go to court. And these hearings are typically telephonic right now. So if an eviction case is filed based on non-payment of rent, the tenant must show up to the hearing and demonstrate a current inability to pay rent. The inability to pay rent does not need to be COVID related, but they have to, explain, for example, I recently lost my job, something like that. So that it's very important that the tenant attend the hearing. If they don't attend the hearing, the court will likely enter a default judgment, which basically will award anything the landlord is asking for, because the landlord will attend and show their case, and the tenant won't be there to provide any defense. So if a tenant is served with a summons for an eviction hearing, they can call the court for instructions on how to appear by telephone. At the hearing, the tenant should explain to the judge that they have the current inability to pay rent. And this doesn't mean that they don't owe the rent. Some courts are still entering a judgment against the tenant for the money amount. It just means that the court will not issue a writ of restitution. So they can't be forcibly removed from the property. There are no protections right now for tenants who have eviction cases filed against them based on lease violations. And one other thing is, in Albuquerque, in Metro Court, they set up a mediation program for non-payment of rent cases as well. So those cases may be referred to mediation to try to resolve the dispute between the landlord and tenant without having to go through the formal court process.
Okay. It's good that they have set up that that program to help people out. And so I just want to make sure that I got this right. It sounds like if somebody receives a notice that they have to go to court because of non-payment of rent, they need to go to the hearing. They need to try and attend the hearing if they can, because if they don't go to the hearing, then the sheriff can then come and evict them from the property if the court finds that the landlord is correct, right? So it sounds like attending that hearing is super, super important.
Yeah, that's right. That's the most important advice we can give people, is to attend the hearing.
Okay. So are there any additional protections for federally subsidized tenants?
Yeah, so in New Mexico, generally there's case law stating that a federally subsidized tenant, for example, if a tenant has a Section 8 voucher, that tenant can request a repayment plan in an eviction action that's filed based on not paying the rent to avoid eviction. And this is a special protection because those subsidies are so valuable, and if the tenant gets evicted, they typically lose the subsidy. So if you're a tenant with a federal subsidy and your landlord files for eviction claiming that you owe rent, you should make sure, again, to attend the hearing and ask the judge to allow you to enter into a repayment plan under the case called City of Albuquerque v. Brooks. It's especially important for tenants to attend these hearings because, again, an eviction could result in losing the subsidy, like losing your Section 8 voucher.
Okay, good to know. And I'm sure it's probably pretty difficult to get those subsidies sometimes. So probably once you get one, you want to hang on to it if you can. So thank you, Riley, for giving us all of that important information on evictions. We have more with Riley, but we do need to take a short break. So once we return, we will continue with Riley, and she will let us know a little bit more information on evictions.
Interested in participating in the SB&M is Here podcast? We'd love to have you. It's as easy as recording from your office. All you need is an internet connection and a phone. To learn more, visit our website at nmbar.org/podcast.
All right, so we are back with Riley Massey from New Mexico Legal Aid, and she is telling us some important information on evictions during the COVID-19 pandemic. So Riley, let's continue. Can you tell us what happens if a tenant misses their hearing, and what can the tenant do in that situation?
So if a tenant misses their hearing and the court enters a judgment against them because they weren't there to present any defenses, they have 30 days to file a motion to set aside what's called the default judgment. However, in eviction cases, to stop the sheriff from evicting them prior to their having a chance to appear before the judge, the tenant will need to file a motion to set aside the default judgment before the date the writ of restitution is set to issue, and that will be listed on the judgment that the tenant should receive in the mail. In the motion, the tenant needs to show first an excuse for being in default, which is the reason why they missed the hearing, which is a pretty easy standard to meet. They could say, for example, they couldn't call into the hearing, when hearings were actually held in court, like they missed the bus, something like that. And the second thing they need to show is a defense to the original action. Right now, the defense could be that the tenant can show a current inability to pay rent and is seeking protection under the New Mexico Supreme Court order. Or it could be that the tenant withheld rent because the landlord was not making repairs. The court will then likely set a hearing on the motion, and the tenant, again, should be sure to attend this hearing and present to the judge their reason for missing the first hearing and their defenses.
Okay, great. And so you mentioned something about a default judgment. So a default judgment, that is like, let's say the landlord comes to the hearing and the tenant doesn't come to the hearing, and the court only hears the landlord's side of the story, and they say, oh, this is owed, right? That's what a default judgment is. Is that correct?
Yes, exactly.
Okay. So, and then like you said, they can then, if the tenant misses the hearing, can then ask for the sheriff to evict them, right? So you want to make sure that you are taking steps if you receive one of those writs of restitution, that you are asking, through a motion, through the court process, to not have that sheriff come and evict you.
Right.
So perfect. So let us know now about, let's say this has happened to you, and you get evicted, or it goes all wrong for you. How does someone appeal?
So to file an appeal, and either party has a right to appeal. The party has to file a notice of appeal with a copy of the final judgment in the district court of their jurisdiction. If the person filing the appeal is low income and can't afford the filing fee, they can fill out an application for free process, which is a form that will ask questions about income, and then they can submit that to the court, and if the person meets income guidelines, the court can waive the filing fees. Once the appeal is filed in district court, the person appealing must also file a copy of the notice of appeal in the lower court, either the magistrate or metropolitan court. And so again, if this is done before the writ of restitution is issued, that should stop issuance of the writ. In New Mexico, a tenant can stay in the rental unit during the appeal if they continue to pay the regularly monthly rent. If they cannot pay the regularly monthly regular monthly rent during the appeal, they may be able to seek protection again under the Supreme Court orders and ask the district court to stop the writ from issuing if they can show a current inability to pay rent.
Riley, question for you. So how long do they usually have between the decision, like say you missed court, you didn't show up, and they give the landlord a default judgment, something like that? How long do you have until the writ of restitution is executed, till the sheriff's actually coming to kick you out of your house?
So that really depends on the specific jurisdiction and how busy the sheriff is, but the court will set the writ to issue between 3 to 7 days after the date of the judgment. So it's a very short turnaround time. And in busier places like Bernalillo County, it may take up to a week from when the writ was issued for the sheriff to come to the unit, but there's no way of knowing exactly when the sheriff will come.
Okay, so it's really important once you get that paperwork that you act immediately, right?
Yes, exactly.
Okay. So can a landlord evict a tenant without going to court?
No, New Mexico law prohibits self-help evictions. So that would include also like turning off the utilities, changing the locks, blocking the entrance. So in order to lawfully evict a tenant, the landlord must provide a proper notice, which would be like a 3-day notice of non-payment of rent or a 7-day notice of lease violation to the tenant, file the case in court, and get a judgment with a writ of restitution from the court. When a tenant is served with a notice, like a 3-day notice of non-payment, it does not mean that they are evicted. It just means that they may have to go to court and present their case. The landlord will still have to file the court case and win it in order for eviction to occur. And this is, again, why it's so important for a tenant to attend the hearing. They have the opportunity to then contest the eviction. New Mexico law also prohibits landlords from threatening to shut off the utilities, and in addition to actually shutting off the utilities. And if a landlord does this, a tenant can then file an action for possession of the property, and the landlord can be subject to a civil penalty of 2 times the monthly rent.
Okay. Well, it's good to know that, there are some protections out there for tenants if, landlords are doing things, like you said, like threatening to shut off utilities or, blocking entrances to properties, changing the locks without court orders, things like that. Can either party terminate a lease agreement given the pandemic?
Yes. So actually, if there's no current lease, either party can terminate a rental agreement by providing a 30-day written notice of termination. The notice has to be served on or before the first day of the rental period to be effective for the end of that rental period. So for example, like a landlord could serve a 30-day notice to terminate on August 1st. The effective date of termination would be August 31st. But if the notice is served after that, like for example, if the notice was served on August 10th, then it would be effective for the end of September. But neither party can terminate a lease this way if the lease is still in effect. So for example, if your lease doesn't expire until December 31st, 2020, neither party can give a 30-day notice until December, unless both parties want to agree on that and sign something called a mutual lease rescission. So if both the tenant and the landlord agree, they should get something in writing stating when they agree the lease is going to end and when the tenant's going to move out, and have both parties sign it. If the tenant stays beyond the date of a valid 30-day notice, the landlord can then file an eviction action, and the parties will still have to go to court, and the landlord must still get a judgment against the tenant to legally evict the tenant. And in this case, there are no protections for tenant under the New Mexico Supreme Court order.
Okay, good to know. And one thing that I've learned, one of the things that I remember is if you are doing something, make sure you try and get it in writing. So I know you mentioned the mutual lease rescission, trying to get that in writing is probably pretty important. And a lot of these things, it's probably important to get some sort of written documentation, just in case people remember things differently. So, even if you can get it in a text message or like an email or something like that. Are landlords still obligated to make repairs? And how does a tenant get a landlord to make the repairs?
So yes, even during the pandemic, landlords are still obligated to make reasonable repairs to rental units, and that's something we've seen coming up a few times. So if the landlord fails or refuses to make repairs, the tenant needs to provide, again, a written notice, so it's important to get it in writing, to the landlord of all of the items needing repair. If the tenant has previously requested the same repairs and the landlord has refused to make them, the tenant should also list the previous dates they requested those same repairs. And then again, the tenant should keep a copy of that written notice so that they have a copy for their records. Once the landlord has been served with the notice, they then have 7 days to make the repairs requested. If the landlord does not make the repairs within 7 days, the tenant can then withhold 1/3 of the daily rent for each day that repairs are not made, going back to the date of the notice. And the legal term for this is called abatement. And typically what happens is, because the tenant is withholding a portion of the rent, the landlord may then file for eviction based on non-payment of rent. So because this is sometimes the case, the tenant should make sure to take pictures of the condition in the unit and keep a copy of that notice so that they have proof of why they withheld the rent. And then again, most importantly, the tenant should attend a hearing if the landlord files for eviction based on rent the tenant withheld due to repair issues. And they can then present that situation to the judge. If the tenant mistakenly withholds too much rent, the court can issue what's called a conditional writ, and the conditional writ gives the tenant 3 days to pay any amounts they should not have withheld. If the amount is paid within those 3 days, the writ of restitution will not issue and the tenant will not be evicted. The tenancy will continue. If the tenant doesn't pay in those 3 days, then the landlord can ask the court to issue the writ of restitution.
Thank you, Riley, for this information. Like I said at the beginning of this episode, I think that there are a lot of legal changes that are happening in the eviction realm, and helping the public keep up with all of these changes is just really important. So thank you for giving us the information on evictions in New Mexico and during the pandemic. I'd also like to thank New Mexico Legal Aid, the State Bar, the Legal Services and Programs Committee, and of course, thank you to the public for listening to these podcasts, because this is hopefully going to be helpful to you in your eviction case. I would also like to highlight that we have a companion episode on unemployment insurance that we have done with Alicia Clark, who is a staff attorney with New Mexico Legal Aid. And so if you have issues with unemployment, please tune in to that episode as well. I believe that we are wrapping this up now. The only other thing that I would like to add is Riley did mention that the Bernalillo County Metropolitan Court does have a free program for people who are involved in landlord-tenant cases in that court. The case does have to be in the Bernalillo County Metropolitan Court for this specific program. But in that program, a trained facilitator will work with the landlords and tenants to try to develop an agreement that is beneficial to both sides. So if you would like to participate in that landlord-tenant settlement program, you need to contact the Metro Court's Mediation Division at 505-841-8167. And that is if you have one of these cases in the Bernalillo County Metropolitan Court.
Thank you for listening. This episode was produced by the State Bar New Mexico Member Services Department and Legal Services and Programs Committee. All editing and sound mixing was done by Blue Sky eLearn. Intro music is by Kevin McLeod at Incomtech. The views of the presenters are that of their own and not endorsed by the State Bar of New Mexico. Nothing said in this podcast is legal advice.